The next point in the sequence of different events that happen in a small claims court is the trial, and after the trial, the end result is a judgment. The judgment, of course, is binding on the parties unless you appeal it, and the judgment is sometimes an oral judgment, which is more than likely, or on some occasions a written judgment where the judge would take the notes and prepare his judgment and give it to the court clerk, who in turn sends it out to the different parties. So the end result of a trial is a judgment, and what is important from your point of view as a lawyer or paralegal is that what are you going to do with the judgment. So sometimes the client will not understand the difference between a judgment and the enforcement procedure. The judgment only deals with the question of your right to have a claim asserted and confirmed by the court, and therefore you have a legal right to enforce the judgment once it is rendered. Now, that does not mean that the opposing party immediately has to take out the checkbook from their pocket and say, I have to pay you right now. So I have seen that also in the courtroom, that when the people or clients do not understand the procedure, they think that the judgment means it's immediately like criminal action. If you are found guilty, you go straight into jail. It's not like that in a civil case at all. It's more like understanding that the court has decided who is right and who is wrong. If a court has dismissed your case as a plaintiff, you don't have a ground to stand on except for cause. If the judge said, yes, you have a good case, and my judgment is that you have a right to collect this amount of money, then you have now obtained the right to collect that amount of the judgment plus the costs and interest. And interest is governed by the Courts of Justice Act, but in terms of the enforcement of the judgment is a different procedure altogether. That's the most important thing to recognize. So how can you enforce a judgment? There are several different ways, of which there are 2 or 3 main ways that I'm going to summarize, and we hope to do a separate seminar on each one of these issues or the topics that I've related in the seminar today. But for the purpose of the judgment and enforcement procedures, the first step you can take is to take the sheriff and then enforce the judgment. The sheriff goes to the defendant's house, knocks at his door and says, I have a judgment and I want you to pay, or I collect your stuff and sell it out and then pay the plaintiff. It usually these days does not happen in that fashion. The sheriff will give a notice, but in terms of your legal right, it is one of the rights that you can exercise after judgment. The second way that you can enforce your judgment is what is called execution. Execution sounds terrible, but what it is essentially the right to have a writ prepared and then filed with the sheriff of the local area in which the defendant has any property. So today it is done to the computers on a TerraView. You plug in the name and the judgment, and it now becomes enforceable against the property, especially real property. So if anybody's going to buy that property and sees the judgment, the TerraView will tell you that there's a judgment against the property and that you cannot buy the property until you have paid the judgment as far as the vendor is concerned or the owner of the property is concerned. And therefore, the lawyers automatically search that and they will not let the property be sold until the judgment is paid. So what do you do after judgment? You file that execution and in the area in which that person has the property. Now it is all on computers, so notionally they are asking you on the computer which area in the county are you in, and you will file it in that county, but you can search the executions across the province these days simply in the TerraView system. So the next method by which you can enforce your judgment is calling a judgment summons examination. Now, in the small claims court, there is a separate form which you can use to say that you wish to then ask the defendant who is required to pay the judgment to come to the court and then complete another form to say what his assets are. Once you have the asset list, you can then tell the judge that he's in a position, that he's got a salary, he's got certain assets, and how would you ask the person to then basically pay up the amount is what the judgment summons examination is all about. It's an examination by the plaintiff lawyer or the plaintiff of the defendant to find out the assets, his income, and all of the details that he can use to enforce the judgment against the assets or even his salary that he earns on a regular basis. So if the person who is being examined does not answer the question or does not appear at the hearing, you have a right to ask that he be jailed for that purpose. So it's called contempt. The contempt is a situation where the person is resisting the giving of information or not appearing in the courtroom to give that information. Now, I've seen errors happen there where people don't show up in the courtroom because for some reason the service was made for them to appear, but they couldn't appear or forgot to appear. It becomes an offense. It is offense that is punishable. And therefore, I think that it's very important that if your client is a defendant and required to appear before a judgment summons examination, that you make sure that he appears. Now, from the plaintiff's point of view, it becomes a remedy of asking the person his assets, etc. And therefore, once you find out what the assets are, you can now begin the enforcement procedures by asking the defendant that if they have a bank account or a property or a job, you know what to do to go and take the next step forward to enforce your judgment. Now, I think suppose you find out that a person has a job, which most people have, then what can you do? There is a procedure called garnishment. Garnishment is a procedure in which you can ask the employer to say, and say to the employer that about 30% of his salary be given directly to you. Now, this involves a certain form, service of the form on the employer, and then the employer has an obligation legally to pay that amount, take it out from the salary of the person and give it to the plaintiff. Now, it has a lot of implications in terms of the person's employment, his ability to survive. Most of the time when a person has to fulfill a judgment and make a payment, they're already in a difficult situation. But the legal right of the plaintiff to collect through court garnishment does exist. And if the employer fails to observe his requirement of doing what he's required to do, you can drag him to court to require him to pay, and he can become liable for not making payment for a portion of the salary that is required to take out and give it to the plaintiff. So I think in this seminar I have tried to review all the different steps that we have to go through to tell the client what steps he will go through, and you go through, unfold the events, and at every stage you have an opportunity to try to settle the matter, and therefore help your client by understanding that we are here in the common law system of adversarial problem solving, that we have first to solve the problem and not just to encourage the client to keep litigating so that we can make more fees. I think it's very important that we see our role properly as lawyers in the adversarial system as problem solvers and not problem creators to try to continue the dialogue of the litigation at any stage when it's not necessary. So thank you very much.